Let's talk about an alleged victim of a criminal case, dropping charges, what's often called dropping a case or an affidavit of non-prosecution. So in a criminal case, it is the state of Texas against the accused person. It is not, the victim versus the accused. And the biggest reason that's important is the alleged victim is not in charge of the case. Whether they do or don't want the case prosecuted is not the deciding factor. And so once the police get involved, once a prosecutor gets involved, they're the decider. A prosecutor can move a case forward against the alleged victim's wishes. And so, I hear all the time from defendants, from the alleged victim, I'm just going to drop this case. And that is a real mistake to think that it's just that simple. It's extremely important to bring a knowledgeable criminal defense lawyer into that case as early as possible to help explain this process and to help both the accused person but also the alleged victim navigate how best to try to drop that case. So I tell people all the time, just telling them you don't want to prosecute isn't going to do it. Signing a form affidavit just saying I don't want to prosecute, that's not going to do it. The prosecutors are always very worried about, I don't want to be the one who dismissed a case only to have it come out later that, the accused person assaulted, the victim again, or God forbid killed them. They're very worried about that. And so they're all about documenting their file, and just I don't want to prosecute isn't enough because, let's be honest, sometimes real bad guys threaten, coerce the victim into signing that kind of affidavit. Or a true victim is only dropping charges because they have no other option. Who else is going to pay the bills? I've got kids to feed, etc. And so prosecutors are worried about that. When people come to me, I listen to the entire story. I try to interview the alleged victim if they'll talk to me and craft a proactive plan to address what really happened and why this case should be dropped. So just saying the victim doesn't want to prosecute is never going to do it. I put together a factual statement. I talk to the alleged victim, I get their side of the story, and I understand how they see the case. Not just, I don't want to prosecute, but here's why, right? It didn't happen the way the police say it did. I was intoxicated at the time. I realize now that I was kind of the first aggressor. I realize now that the accused person, thought they were defending themselves. Whatever the issue is, right? I want to understand the facts, understand the law, and then try to put together the best possible affidavit. And sometimes that's no affidavit. If there's no way we can put together an affidavit that's going to help the accused, I don't want to do more harm than good. And so that's sometimes part of the process of involving a good, smart criminal defense lawyer is knowing when the best plan is to keep your mouth shut and do nothing so that you don't make it worse. And then, in the good instances where I think there's a clear shot where we can really help the case, then that's crafting that and helping that alleged victim understand how to interact with the district attorney's office, what to say and not say, so that they don't end up making it worse. So these are things that a good criminal defense lawyer can help walk you through in your case, and something that you should think about in any criminal case, whether you're the accused or the alleged victim. If you're hoping the case gets dropped, you need to involve a smart, knowledgeable lawyer early.